no longer make these decisions yourself. Next, there is the durable general power of attorney. So this is really, we call it the financial power of attorney, just to keep it simple and in plain English. So you've got your healthcare and now a financial power of attorney. So this is the person who's handling finances and working on your behalf, moving money around if need be, signing tax returns and applying for benefits and stuff like that if you can't. So they're in place to do all these financial and legal things on your behalf. And it's the same thing. If you're part of a couple each other, but then one person, then a backup, and then a third just in case person. So you have that succession lined up. These lists are often different people. They can be the same, but this is something that I always encourage people to really stop and take a look at. Who is best equipped to do whatever that job is? There are a lot of people out there who would be absolutely fantastic to help you make these medical decisions on your behalf if you weren't able to. But they may not be financially savvy at all. On the other hand, you've got someone who's very financially savvy, but oh gosh, you do not want them making any kind of health or medical decisions for you. Look, that's fine. Different people have different strengths. I sometimes see people, they end up really racking their brain and delaying doing anything because they're trying to find Superman or Wonder Woman. They got to be able to do it all. Well, no, different people have different strengths. So that's the first two documents. Third one, this is the living will. Some of my clients kind of joke around and go, it's quote the pull the plug document. This is actually the document that says, here's what my wishes are. If I get to the point where the doctors and medical personnel are saying, look, there's no coming back. You are terminal and incurable, or you're in a persistent vegetative state. This is it. However, we can keep the body going on the machines and the nutrition and the hydration. That's when most of my clients are saying, no, look, if I reach that point, just let me go. This is the document so no one else has to actually make that decision. Once, then we do it as two physicians. Once two physicians have certified that you are in that condition, they're instructed to just let you go. So that's the third document. Fourth document, this is really around guardianship. If you get to that point where you can no longer make any kinds of decisions for yourself, and it's a sustained long-term thing, and somebody's going to go to court and say, I want to become the conservator, I'm going to be the guardian of this person. And well, okay, that's kind of what the healthcare and the financial power of attorney is for. But just to make it very clear, if this is something that becomes necessary enough that someone's going to go to court over it, all right, you're naming the same people to do financial things, your conservator of the estate, and the same people making the healthcare decisions, your conservator of the person. Those lists all line up. Now, the hope is that you don't go to that. So I sometimes see people, well, okay, we're just going to go and get guardianship for someone who might be capable of executing power of attorney documents. Well, why would you do that? That's like specifically saying, I don't trust these people enough. I need to bring the court into this process. Well, you don't need to do that if you've got the power of attorney documents. So this is just a kind of backup. And then the fifth one, this is the last will and testament. Where does your property and assets go after you've passed on? And it ends up getting handled through the probate system. Right. So again, this is non-negotiable. Most of my clients want to avoid probate, and we're going to talk a little bit about that when we're talking about the planning for you. So that's the first section. Those big 5 documents: healthcare power of attorney, financial power of attorney, living will, nomination of conservator, and the last will and testament. All right. So now we're talking about putting together planning in case of benefits for you. So early on, if you're still capable of handling everything, This is one of the things with HD. It's a debilitating thing over a course of time. It's usually not extremely rapid, and it's not, okay, over 40 years. There's a time frame, but it varies. If you're perfectly fine, even though you've got this diagnosis, or it's not perfectly fine, it's not that bad, you want to maintain control of your own stuff as long as you possibly can, balanced against what if there are benefits that are needed, such as Medicaid. Right. So this is where a revocable living trust can come into play. And it's planning around not just your estate should you pass on, but also incapacity, and keeping it out of the court's reach. This is just a kind of fundamental thing. The less you can have government and the court involved in your plan, the better off you're going to be. Anytime a government or a court has to oversee something, it becomes a lot more expensive. There are a ton more attorney's fees. It's not kept out of the public. It's right there in front of everybody, which is why you don't want guardianship if it's at all possible, if you can handle it privately. But now this is a way to sew it up even more tightly, because having a revocable living trust means you're moving assets into the trust. You can remain the trustee over your own assets as long as you're capable of doing that. And then if you reach the point where physicians have said, look, you just really can't handle your own affairs, you don't have to actually be incapacitated or, quote, incompetent under the law. Just you can't handle your own affairs. Well, then this kicks in. And now your successor trustee is stepping in and managing all the stuff for you outside of the court. And when you pass on, this trust and those assets end up going to the people that you want it to go to at the time you want it, with all of the different contingencies and maybe age restrictions for younger beneficiaries. All this stuff is happening inside that revocable living trust without having to get a court involved. And a lot of my clients preferred that method of doing it. But this also comes along with all of those other documents that we mentioned as the non-negotiables, the essentials. So you also get the healthcare power of attorney, the financial power of attorney, the living will, the nomination of conservator. Now, here's the things with the durable power of attorney and the last will and testament and how those kind of work together with the revocable trust. Not everything goes into the revocable trust because there might be a solid tax or other reason. Life insurance. If you've got life insurance, there's really no need for the trust to own the policy. It just needs to pay into the revocable trust upon death, and then all those beneficiaries are taken care of. And usually life insurance companies are a lot more in tune with using that durable general power of attorney. If you become incapacitated, they'll just go ahead and handle the instructions of the power of attorney. Not so much with banks and stocks and bonds and other things. It's better to have it inside the trust, but it's a lot more paperwork to move the life insurance into the living trust. IRAs and 401ks, okay, if you move that into the revocable trust, Uncle Sam says, thank you, we want all of our tax money in 1 year, any penalties and whatever, just okay, yep. It's as if you pulled all your money out if you move your retirement account into your revocable living trust while you're alive. So, okay, no, you don't want to do that. But this is where that power of attorney comes into place. This is also why it's really important that the list of the people that you have as your trustee also is the same list of people that you have for that durable general, that financial power of attorney, so it all lines up. Now, we're also talking about the last will and testament. You have your executor. It should also be the same list of 3 people. But now the will doesn't describe, oh, this goes to this person or this goes to that person. In fact, this is one of the, quote, 5 toxic lawyer schemes that are out there. They'll duplicate everything in this, quote, pour-over will. You don't want that. You only want, okay, here are my executors, and if anything ends up in probate, send it to the revocable trust. That's the only beneficiary. And now all of those allocations and distributions happen outside of the court's oversight and outside of the public view. That's what most of my clients want. Now, here's some very specific things related to HD. I have several clients who were diagnosed, and they understand this. There are things that are coming down the road. And so we have put together some special modified language to what counts as incapacity to remove someone as a trustee. There's a phase of HD where it's extremely common for people to just kind of be a lot more reckless with finances and personal relations. Okay, you don't want to be in charge of that if you're going through that phase. And so it's not the typical medical diagnosis that the physicians have to certify to get you pulled out as the trustee. We've modified the language so it works specifically as well with HD, and taking you out of potentially being extremely wasteful or reckless with the finances if you end up going through that phase. So that's something that we put into place. And also, it's just at that point, if you've reached that point, you need to be notifying, or not you, your successor trustee who's stepping in and taking care of everything for you. They need to notify all these financial institutions, hey, look, they're no longer capable. And so that takes all of those assets off the table, and now they can look out for your best interest if you're going through that phase. So this is planning your own estate out. So what about if it's a little bit later? We're reaching that point where benefits such as Medicaid for nursing home care may end up being down the road. You see that it's coming. All right. Now we're talking about a whole big shift in what's going on, and you can't be in control anymore. And in fact, you need to, quote, get your assets as far away from you as possible in order to qualify for Medicaid and these other programs. Now, there are a lot of different programs that are out there that are designed specifically for different types of disability. We're only going to talk about Medicaid just because the requirements for assets are so stringent that if we can qualify for Medicaid on the asset side, you're probably, not definitely, but probably going to be qualified asset-wise for all of the other programs if they even have these asset tests. So that's the one that we're talking about. Now, setting up for this potential Medicaid application and getting these assets off the table, we're really putting together several trusts. Now, we call it the two-trust solution. For each person, it's usually 4, but the two main ones. We have an irrevocable family trust. This is where all of the, quote, action is taking place in terms of an estate after you're gone. But for now, it's whatever financial assets, non-real estate, all your financial assets that you want to protect are now going into that irrevocable family trust. We have an irrevocable property trust. It's just slightly different, and we'll talk just a little bit about that, but I have other courses and webinars specifically that go into a lot more depth. But an irrevocable property trust is where you move the real estate. So you move the real estate into the irrevocable property trust, and now you're allowed to keep using that property. You're liable for all of the taxes, and you have the right to the income. But here's the big benefit for the family after you're gone. The way capital gains taxes work on the sale of real estate, it's if you purchase real estate, it accumulates in value, you turn around and sell it later on, you're paying capital gains taxes on the difference. when anyone passes on and they control something, all right, the estate tax laws say, well, your cost basis bumps up to fair market value, so there wouldn't be any capital gains taxes from the date of death value. So if that real estate gets sold, say 6 months later, just generally speaking, they're not going to have any capital gains taxes on it. However, if you took that real estate and moved it into the irrevocable family trust, which is a lot more stringent and doesn't give you the right to the income or the right to use or live on the property, okay, you're going to have capital gains taxes from whatever you purchased that real estate at to the date of death. And it's just a lot more in capital gains taxes. So we want to avoid that. So that's the irrevocable family trust has all of the financial assets. The irrevocable property trust is where you move the real estate. Now, the two other trusts that we put in place, honestly, this isn't needed for North Carolina and several other states, well, around half the states. And there is, in some states, an income cap on whether or not you can receive that nursing home, skilled nursing care level of Medicaid. But there was this big lawsuit about it under, equal protection under the law. And so they came up with this trust solution. If you're, and let's just give you the example. The cap is at $3,000 a month in income. If you have any more than $3,000 in income, you're not eligible for Medicaid. Well, okay. What if you have $3,100 a month? You can't get nursing home level Medicaid for $3,100 a month. That care is really, it's getting close to about $10,000 a month. So, okay, you're ineligible. What do? Do they roll you out into the street and let you die? No. So what the solution was, it's something called a Miller Trust, a quote special needs Miller Trust. Your income goes into the trust each month. It then is counted as an asset. You spend it down, and then, so essentially, if you're in that nursing home, the money comes in, check goes out from the trust to the nursing home, and it's as if it's washing away the income. North Carolina doesn't have this requirement, but we still do the trust just in case down the road the legislature decides, oh, well, we're going to become one of these states that does count that for income purposes. And then the last of those irrevocable trusts, that kind of Medicaid planning trust, is the irrevocable funeral trust. We don't typically put money in there unless it comes down to it, but it's really designed to be there for that last up to $10,000 that you need to set aside in order to qualify for Medicaid. So the example is, okay, everything's been shifted, everything's moved around, but you've got $7,000 and you need to get it below $2,000. All right, you can take $5,001 and move it into this irrevocable funeral trust, and it's there for burial, cremation, and all the other stuff that qualifies for a trust like that. And it's off the table, and it's not considered a gift. You don't put it in ahead of time because, well, okay, then you're going to end up potentially needing someplace to put that extra $5,000. So it's there just in case it's needed as the last minute spend down part of the process. All right. So those are the four big ones. The big thing is when you move money into the irrevocable family trust and the irrevocable property trust, it's 5 years from the date of transfer. And this is a big misunderstanding that often happens. Well, I signed the trust on this date, but I didn't move my assets in for another 3 years. Well, no, the clock starts from the point of transferring it in, not when you sign the trust. So each asset is considered a transfer. So by the time the last asset goes in and there's this 5-year period, that's when you know it's free and clear. Don't want to get into any more complications than that. So this is where, okay, 5 years, we're moving the money in. We've got 5 years until we're going to need care, probably. And then, okay, we're good after that. Well, what if you need care halfway through? Well, let's just say it's 3 years in and nope, you need that skilled nursing level of care for long-term care needs. All right. your trustee can take money out of the irrevocable family trust, and this is the way it has to be. They're, quote, putting it in their own pocket, and then they're turning around and paying those bills for that 24 months. So they get to pull that money out. Now, technically, you can't be the beneficiary of this irrevocable family trust. It's really your trustee who is the beneficiary up until the point you pass on, and when all the estate stuff kicks in. So you really have to trust that trustee is going to have your best interests at heart, because legally they could just take the money and put it into their pocket. So these are discussions that we have with our clients when we're talking about this type of planning. But this is a way that you can shelter those assets over that period of time. And if you get past that 5-year mark from those assets going in, okay, as far as Medicaid's concerned, you never owned it. Right? So what if you don't have 5 years? All right, look, there are a ton of different things that can be done if you're working with someone like a certified Medicaid planner or Medicaid planning attorney who really is experienced and understands all this stuff. I've gone through some special training, and I'm a certified Medicaid planner, so I know a lot of these different tips. There's no one or two ways that this is absolutely the way it's always going to be, and so I can go ahead and no, look, it's so situational. But here is a case that worked. And I'm rounding the numbers, and it was from my 2 estate planning clients, a couple. It was her mom. She was the power of attorney for her mom, and mom was in a kind of memory care unit, but look, she could do everything. Feed herself, clothe herself. It's just that her memory issues were bad enough that they couldn't just let her walk out and go to a car and drive around. She would get lost, she'd get confused. She just needed that supervision. And so her care, it was actually only costing her, beyond the income, like $6,000 a year, which her assets were kind of making up for in terms of growth. But if it got any worse, if the level of care had to go up, suddenly that money's going to end up being drained pretty quickly. So I'm rounding the numbers again, she had about $340,000 in a checking account, and she had a whole life policy that had about a $60,000 of cash value, but about $400,000 death benefit. All right. Medicaid would look at that as $400,000. So $340,000 in the bank, $60,000 in the cash value. They only count the cash value. They don't count the death benefit. They say, okay, you've got $400,000. If she just went and applied for Medicaid, they'd say, you need to spend down $398,000. All right, well, what could we do to not have to do that and not have to wait 5 years? Because there was, at any point, it could have gotten worse. We don't necessarily have 5 years here. All right. We started looking at the daughter and son-in-law's assets, and they had a house worth $500,000 that was paid up. Well, she's allowed to have a primary residence, even if she doesn't own all of it herself. And I have to throw in this caveat here. This works in North Carolina. It doesn't work in a lot of other states. Okay, I've said that, but again, this is why these techniques need to be looked at, and there's no one or two ways, because every state can have some different rules. So if she decided, well, mom wants to buy into their house, she could own 80% of that house and own it with her son-in-law and daughter as 80% mom, 10% daughter, 10% son-in-law, the three of them owning it as joint with a right of survivorship. So if mom passes on, they're getting the house back, and she gets to buy in for the $400,000. Oh, okay. So we were able to put together a deed and a contract. So mom was buying into the house. It can't just be a gift. It had to be buying into the house. Well, wait a minute. We have that life insurance policy. Do we just cash it out? Well, no, she was really kind of counting on that 400,000 being the inheritance for the 4 kids. So the daughter was just one of 4 kids. She wanted that to be part of their inheritance. So what can we do? Son-in-law buys the life insurance policy for whatever the cash value is. So now he owns the policy, and mom got the $60,000. So now it's $400,000 in cash. Okay. Signed the contract, wrote the checks. They get the $400,000, the daughter and son-in-law. They go, all right, well, we did sell part of our house to mom. It is our money, but ethically, morally, we're just going to look at this as if it's mom's money. They take the $400,000 and they move it into that irrevocable family trust. And now there's no 5-year look back period because mom wasn't the one who put the money in. It wasn't a gift or a transfer from mom. Hers was a purchase. Okay, that money goes into the trust. So now, on paper, she doesn't have anything. Well, she did have a checking account. We kept a little bit of money there, but we just have to spend that down to under $2,000. And asset-wise, she would have qualified for Medicaid. What do they do with that $400,000 once it's in the trust? First thing they do, they buy the life insurance from the son-in-law and move it into the trust. And now that irrevocable family trust is the beneficiary. So when mom passes on, the money goes into the irrevocable family trust and then can get distributed to the 4 kids. So we were able within a couple of months to shift assets around. So there are ways to do this, even if you don't have 5 years. All right, so we're really getting long on this, but it is an important topic. So we've just got one more phase to look at, which is what if you're not the person with HD, but you're trying to plan your estate the right way so that the loved one who does have HD can benefit, but not lose whatever their benefits are. So this could be parents leaving an estate to children. It could be if you have a parent with HD, but you want to make sure that something in your plan is going to benefit your parent or siblings or some other type of relation. You can set up your revocable living trust and so handle all your estate and remain in control, no issues. But if you pass on, now anything that you are leaving to the person who's diagnosed with HD is held up in trust in the hands of the trustee so that they can benefit without that money actually being on their balance sheet for benefits purposes. So they don't quote own it. The trustee is administering for them so they can make sure they're getting what they need without the necessity of the person applying for benefits who does have HD. It's not something that's going to disqualify them. So this is just, it's in trust, held off to the side, and it's there for the trustee to help take care of them. That's really the easiest thing. And this is something that's very, very common in the revocable trust that we do. Not all trusts are the same, and I have to make this point very clear. There are a lot of people, a lot of attorneys out there who do what we call, quote, thin trusts. These are the much cheaper trusts. The price always sounds great, but it doesn't have these other provisions in it that necessarily lock things up as tight as they need to be in case someone is receiving benefits or they could be receiving benefits down the road. They don't end up having this money go directly to that person and therefore, they're disqualified. I just kind of got consulted on a case with a gentleman, and dad never changed his plan. Mom never changed her plan, but the son has some pretty severe schizophrenia, and he does have disability. He does have Medicaid, and this is something that could mess with his benefits if he receives the inheritance. is some of it's locked up, the rest of it isn't. So if you're putting together your plan and you want to put it together in a way that makes sure that a loved one who has or could potentially have HD, it's locked up, you have to make sure that you're doing the planning the right way so that they never fully get the whole inheritance. It's held in trust for their benefit. And this is something that we have standard in the revocable trust that we work with. All right, so that was an awful lot. If you are interested in having a look at your particular situation, your family situation, your financial situation, your medical situation, and you want to look through all of this, then please let us know, set up an appointment, and be sure to let them know, yeah, we've gone through this live stream, we've seen this, and we understand a lot of the concepts. My office is still going to say, okay, we'll go into this program that we have online called freetrustcourse.com. And again, freetrustcourse.com. Go ahead and go into it. It's, as the name says, it's free. It's going to talk about revocable living trusts. It's not going to talk about the advanced stuff or the irrevocable trust for Medicaid planning that we talked about. And it's going to have a questionnaire to fill out, and that should be enough for us to get started. All right, so as I close out all my videos with, I hope you found that information useful. As I always tell my clients, please stay safe, plan ahead, and enjoy life. And whatever you do, make it a great day. And if you are here as part of the live part, we're going to have the Q&A start now.
Okay, well, thank you very much, everybody who hung on. And particular people who switched over from Facebook, I apologize. I've got all these different Facebook groups, and it was supposed to automatically go there, and apparently it's not automatically going there. All right, so we're just going to open it up for whatever questions you've got. Hey, this is just an opportunity to go ahead and put that out there. Now, I want to thank HD Reach. They are actually in the comments, and they did make a comment that this is an example of how important it is to choose the right trustees. And that is so important, particularly with those advanced irrevocable trusts that we talked about. You're essentially giving them any of that money that's going into the irrevocable family trust in a way that they have all that money, and they would have to take it out and give it to you kind of personally as a two-step process. They can say no. So you really, really have to trust that person that you're making the trustee to handle things. So please go ahead and put whatever kind of questions you've got in the chat. This is just a great way to get a little bit of more general information that might be just a little more specific to you or your loved ones. But like I said, we can always go and do a sit down and run through your particular situation. Now, I do want to also make sure that we're putting out the other program that we have out there. I mentioned the freetrustcourse.com. There's also freemedicaidcourse.com. In fact, give me a second. I'm actually going to try to type this into the chat one-handed. So eventually I'm going to be at the point where I have a moderator on these. So, and if we get any volunteers, let me know. But it's free Medicaid. You know, it would help if I could spell course. There we go. So freemedicaidcourse.com. It's kind of that same thing along the lines of free trust course. It just kind of runs through some of the basics. Freetrustcourse.com has my book, Estate Planning Basics, in a digital format for free. There's an audio format, and there's kind of a read-along video with audio, and almost the same thing at Free Medicaid Course with my book, The Long-Term Care Solution, which goes a little more into the irrevocable trusts. Okay, is your office available for virtual appointments or only in person? Oh gosh, I have gotten so familiar with Zoom. Yes, we can do virtual appointments via Zoom. In fact, I'd probably say these days it's about 50-50. Although if my clients in the process, if they're going to mix up some Zoom, some in person, they can try to come in for that initial first meeting when we run through things because they want to see me face to face. And okay, that's great. But yeah, we've gotten a lot of meetings that we even start out via Zoom. The one thing that I do have to make sure that I put out there, though, is the signing. Unless medically there's no way you could actually come to the office for the signing and we have to go to you, we can discuss that. The signings still have to be in person. And for all of the reasons that I put in a very recent video about digital signings, that just can't happen with these types of documents. So please, yeah, definitely let us know. We can set up a Zoom. I might as well go ahead and I can put out the law firm's phone number into the chat as well. And it's these days it's Hazel or Jennifer who would be taking the call and getting back to you and scheduling anything. So yes, thank you for that question. All right. Any other questions? We're going to give it a minute or two because I know there's about 60 seconds between me asking the question and it coming up. So, okay. Well, for Keep Calm, Kate, she thanks us and thank you for the question. All right. If someone is gene positive for HD, not yet symptomatic, how soon should I be thinking and preparing documents and finances? Good question. And the answer is, look, as soon as possible. It never hurts to get information. It never hurts to lay things out. Get a plan in place. Even if you're like, okay, we don't necessarily need to do these documents or start shifting stuff now, particularly when it's irrevocable. When it comes to Medicaid and we're talking about irrevocable trust and moving your assets into irrevocable trust to start the 5-year clock, you're giving up a lot of control, and not everybody is necessarily ready to do that until they see that there are some issues. But it never hurts. And this is something for all of my estate planning clients when we have an annual review because they've got a revocable living trust. It could be a young couple with no medical issues in their 30s. Every other year, we're still going to talk about long-term care planning and the potential for using irrevocable trusts and things like that if it's needed. It never hurts to get that information. So thank you for that question. All right. Do we have any other questions? Okay. When it comes to Medicaid, if the Medicaid office says the only solution is to spend down your money, it sounds like there might be other options. Okay. Yes. Here's the big thing. The Medicaid office is not your friend. They are not your counselor. They are not there to help you. They're there to get you to spend all of your money down first. So I always tell people, look, don't go to the Medicaid office. And in fact, don't go to the Medicaid office just to get some answers because bad things can happen. I have had clients, and I've said, don't go down to the Medicaid office. Let us know what's going on. Oh, look, we'll just go and get some answers. And they went down and they said, oh, sure, we can help you. Here, go fill out this form just so that we know what we're doing. And they filled out the form. It's like, okay, go ahead, sign it at the bottom. They signed it at the bottom. Your Medicaid application has been denied. What application? We just came down here to get some. No, you just filled out an application. See right there under penalties of perjury. You're filing a Medicaid application. And now suddenly they come back to me and it's a lot more difficult to actually make these moves because there's a rejected application already on file. And one really sad case, we had a gentleman who came in. It was him and his son, and he was trying to get Medicaid for his wife. They actually talked him into pulling money out of the equity in his house to pay for her medical bills. And that's something that Medicaid would have paid for. It could have come from other sources. And they actually ended up putting them in debt, not just spending everything. So Yeah, the Medicaid office, there are some really good people who work down there, uh, but they're not allowed to help you save money. There is a lot more that you can probably retain if you know what the rules are. And I hate to put it this way, but if you know the rules, you can win the game. And that's just the way it is. All right. Do we have any more questions? I hope everybody is enjoying the little bit of the warmer weather that we're getting right now. Personally, I'm waiting. We've got about a week and a half before Durham Bulls baseball season starts. So if you follow me at all in any of the other social media, from uh, late March, early April, all the way through the middle of September, we're posting stuff from the Durham Bulls baseball games. So, okay. All right. Well, I am not seeing any other questions right now, but that doesn't mean you can't ask questions later. And this will end up going up and being up on YouTube as a live stream that you can keep going back to. And I do check those comments. So, like I said at the beginning of the first part, just as I always tell my clients, please stay safe, plan ahead, and enjoy life. And whatever you do, make it a great day. Oh, sorry. Coming back, we got one more question. Are these big five documents only recommended for those 18 and over? Any recommendations for parents whose children have juvenile Huntington's who are under 18? Those documents are only for people 18 plus. Prior to age 18, okay, that's when it's the parents who are in charge of things. Now, I have had some clients bring their children in like within a week or two of their 18th birthday to get their stuff put together, or at least the power of attorney documents, the healthcare and the financial power of attorney documents. But on the juvenile end, it really becomes more of the parents making sure that their estate is set up in the right way, and making sure that if anything happens to them, that there are successor guardians, and probably starting to go a little bit through here's what the finances are and how it's going to be once they do turn 18. So good question. We're going to close with that one. So thank you all again for being here. And please let us know if there's any other questions or any way we can help. Have a great night.